Dealing with an estate administration is a complex task, made even more challenging when estate heirs are missing or uncooperative. Executors and personal representatives must navigate legal, financial, and emotional hurdles to ensure the estate is settled in accordance with California law. I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law. In this video, I'll explain how to handle missing or uncooperative heirs. The first step in handling missing heirs is to make a diligent effort to locate them. Here are some strategies. Public notices. Publish notices in newspapers and online platforms. This is a legal requirement in California and helps in reaching a wider audience. Professional tracing services. Engage a private investigator or professional heir tracer. These experts use databases and investigative techniques to find missing family members. Social media and online searches. Utilize social media platforms and search engines to track down heirs. Many people have an online presence that can provide clues to their whereabouts. Government and public records. Access public records such as birth, marriage, and death certificates, as well as voting records and property records. It's crucial to document all efforts made to locate missing heirs. This documentation will be essential when dealing with the court. Keep records of all communication attempts, such as emails, letters, and phone calls, copies of public notices, and reports from professional tracers or private investigators. When heirs are missing or uncooperative, seeking legal advice from an experienced probate attorney is imperative. An attorney can provide guidance on issues including filing a petition with the probate court. If heirs cannot be located, the court may allow the estate to proceed to distribution without their involvement. This often requires providing that exhaustive efforts were made to find them. Dealing with uncooperative heirs. Legal advice is crucial in handling uncooperative heirs, particularly if they dispute the will or refuse to sign necessary documents. Mediation may be recommended to resolve conflicts without going to court. For missing heirs, the estate administrator may set aside their share in an escrow reserve account. This ensures that if the heir later comes forward, their inheritance will still be available. Consult a probate attorney to determine the appropriate amount to set aside and conditions for the escrow. Dealing with uncooperative heirs requires diplomacy and legal acumen. Here are some strategies to consider. Open communication. Try to understand the reasons behind their uncooperativeness. Open and honest communication can sometimes resolve misunderstandings and grievances. Mediation. Involving a neutral third party to mediate can help resolve disputes without resorting to litigation. Mediation can save time, money, and preserve family relationships. Court intervention. If an heir continues to be uncooperative and obstructs the estate administration process, seeking a court order might be necessary. The court can compel the heir to comply or make decisions in their absence. For heirs who are minors, mentally incapacitated, or otherwise unable to represent themselves, the court may appoint a guardian or representative to act on their behalf. This ensures that their interests are protected and that the estate administration can proceed smoothly. In certain jurisdictions, if exhaustive efforts have been made to locate missing heirs and a reasonable amount of time has passed, the court may permit the estate to be distributed without their consent. The unclaimed share might be held in trust by the state or transferred to a government agency until claimed. If heirs reside in a different country outside the United States, additional complications may arise due to varying laws and regulations. Here's how to handle such situations. Legal assistance. Hire an attorney with expertise in international estate law to navigate the legal complexities. Translation and communication. Ensure that all documents and communications are translated accurately. Consider time zone differences and international mailing times when planning. Compliance with foreign laws. Be aware of and comply with the inheritance laws of the heir's country, as they may differ significantly from your own. Once all efforts to locate or deal with uncooperative heirs have been exhausted, and with legal approval if necessary, proceed with the final accounting and distribution of the estate. Ensure all records are meticulously kept to protect against future claims. Final report. Prepare a final report detailing the administration process, the efforts made to locate heirs, and the final distribution of assets. Submit this report to the court for approval. The release of liability. Obtain signed receipts from beneficiaries acknowledging they have received their inheritance. This can protect the executor or administrator from future claims. Handling missing or uncooperative heirs in estate administration requires a balanced approach of diligence, legal compliance, and empathy. By following these steps, executors and administrators can navigate these challenges effectively, ensuring the estate is settled fairly and in accordance with the law. Seeking professional legal advice and documenting every step of the process are critical to a smooth and successful estate administration. If you have any questions about how to handle missing or uncooperative heirs, please feel free to contact our office.